Think about the last time you interacted with your bank. Maybe you checked your balance. Maybe you disputed a charge. Maybe you paid a fee you didn't fully understand on a service you didn't fully choose, governed by terms and conditions that ran 40 pages long and that no human being has ever actually read in full. Now ask yourself this: who decided the rules of that interaction? Who determined what your bank can charge you, what it has to tell you, what it is forbidden from doing to you, and what recourse you have when it does something wrong? You might say Congress. You might say the Federal Reserve. You might say the FDIC, the CFPB, the alphabet soup of regulatory agencies that exist precisely to sit between financial institutions and the people those institutions serve. And you would be partially right. But you would be missing the most powerful player in the room, the one that most people never think about when they think about money. The Supreme Court of the United States. 9 justices, lifetime appointments, no election, no term limit, no direct accountability to the people whose lives their decisions shape. And in February 2026, after a series of landmark rulings that have fundamentally restructured the relationship between the federal government and the financial system, the Supreme Court's fingerprints are all over your bank account, whether you know it or not. Today, we are going to make that visible, because what you don't know about this can cost you. To understand where we are, you need to understand a concept that rarely makes financial headlines, but has quietly transformed American economic regulation: the doctrine of agency deference. For decades, the operating principle in American law was that when Congress passed broadly worded legislation, the expert agencies created to implement that legislation, the Consumer Financial Protection Bureau, the Federal Reserve, the Securities and Exchange Commission, the Federal Deposit Insurance Corporation, had broad authority to interpret those laws and write the specific rules that put them into practice. The logic was straightforward. Congress passes laws, but laws cannot anticipate every specific situation. The agencies, staffed by specialists with deep expertise in their domains, were better positioned than courts to make technical regulatory judgments. If a banking regulation was ambiguous, the agency's reasonable interpretation would stand. Courts would defer. This framework was codified in a 1984 Supreme Court decision called Chevron v. Natural Resources Defense Council. It became known simply as the Chevron Doctrine, and for 40 years, it was the bedrock on which American financial regulation was built. In June 2024, the Supreme Court overturned it. The ruling in Loper-Bright Enterprises v. Raimondo did not make headlines in the financial press the way an interest rate decision would. It did not trigger market reactions. It did not prompt emergency congressional hearings. But in terms of its long-term impact on the financial lives of ordinary Americans, it may prove to be one of the most consequential legal decisions of the past generation. Here's what it means in practical terms. When a regulatory agency, say the Consumer Financial Protection Bureau, writes a rule limiting the fees banks can charge on overdrafts, that rule used to carry significant legal weight. Courts would generally uphold it as a reasonable exercise of agency expertise within the broad authority Congress had granted. After Loper-Bright, those rules are exposed. Any affected party, meaning any bank, any financial institution, any corporation that dislikes a particular regulation, can now challenge that rule in court, and courts are no longer required to defer to the agency's judgment. They apply their own interpretation, and depending on which courts hear those challenges, the outcomes will vary dramatically. What this creates, in practical terms, is a multi-year wave of litigation aimed at dismantling financial regulations that have been in place for years. Rules protecting your ability to dispute credit card charges. Rules limiting the fees banks can extract from low-income customers. Rules requiring financial institutions to disclose the real costs of complex products. Rules governing how debt collectors can contact you. Rules setting standards for mortgage lending. All of it is now subject to legal challenge in a way it was not before. And the entity deciding which challenges succeed is ultimately the Supreme Court. But the Chevron ruling is only one piece of this, because the court's influence on your financial life runs deeper than any single doctrine. In 2024, the Supreme Court also heard a direct challenge to the Consumer Financial Protection Bureau itself. The CFPB was created in the aftermath of the 2008 financial crisis, specifically to protect ordinary consumers from predatory financial practices, and it has been a political target since its founding. The challenge before the court questioned whether the CFPB's funding mechanism was constitutional. The Bureau is funded by the Federal Reserve rather than through annual congressional appropriations, a design choice made deliberately to insulate it from the political pressure that industry lobbying can exert on the appropriations process. The court ultimately ruled in favor of the CFPB in that particular case. The Bureau survived. But the fact that its very existence was a live legal question before 9 unelected justices tells you something important about the fragility of consumer financial protection in the current legal environment. The CFPB survived that challenge, and the next challenge may look different, and the composition of the court itself changes slowly but permanently with each new appointment. Let's be concrete about what is actually at stake for ordinary people. Overdraft fees. Banks in the United States have collected billions of dollars annually in overdraft fees, often charged to the customers least able to afford them. The CFPB has repeatedly attempted to regulate these fees, most recently with rules that would cap overdraft charges at amounts more closely tied to actual administrative costs. Without the backstop of Chevron deference, those rules face serious legal jeopardy. If they fall, the fees come back. If you are a lower-income American who uses a bank account as your primary financial tool, this is not abstract. This is your money. Credit card fees. The CFPB finalized a rule in 2024 capping credit card late fees at $8, down from an average of more than $30. That rule faced immediate legal challenge. Courts blocked its implementation pending litigation. In a post-Chevron world, the path to reinstating that rule runs through a judiciary that is no longer required to respect the agency's expertise. The credit card industry collected approximately $14 billion in late fees in 2023 alone, and it has every financial incentive to keep the legal pressure running. If those fees return to their previous levels, American consumers collectively pay billions more per year to use a product and they often have no practical alternative to mortgage protections. The rules governing how mortgage servicers must treat borrowers who fall behind on payments, rules that came directly from the post-2008 reform era, are embedded in regulatory frameworks that are now subject to enhanced judicial scrutiny. The specific protections that allowed millions of Americans to avoid unnecessary foreclosure during the pandemic pause are products of the same regulatory architecture that is now under legal stress. Payday lending. The CFPB's rules limiting the most predatory aspects of the payday loan industry, products that trap low-income borrowers in cycles of debt at effective annual interest rates that can exceed 300%, have been fought in court for years. Without Chevron, the legal landscape for those rules gets harder, not easier. Data privacy and financial surveillance. As financial data becomes more valuable, the rules governing how your bank can collect, share, and profit from your transaction history are increasingly set by regulatory guidance rather than explicit statute. The weakening of deference to agency interpretation means those rules are more vulnerable. Each of these sounds like a specific policy issue. Together, they form a picture of the architecture of protection, or the absence of it, that sits between you and the financial system every time you swipe a card, pay a bill, or carry a balance. Now let's go one layer deeper, because there is a dimension of this that goes beyond any specific ruling or doctrine, and it involves the question of who the Supreme Court is ultimately accountable to. Federal judges, including Supreme Court justices, are not elected. They are nominated by presidents and confirmed by the Senate. Their appointments are permanent. They cannot be removed except through a process so rarely used that its practical relevance is near zero. And crucially, the cases that reach them are not randomly selected from the population of all disputes. They are chosen by the parties who bring them, by the legal organizations that fund the litigation, by the circuit courts whose split decisions create the conditions for Supreme Court review. The financial industry spends enormous resources on legal strategy. It employs the best appellate lawyers in the country. It funds think tanks and legal organizations whose explicit mission is to shape the legal environment in which financial regulation operates. When a major bank or a credit card network decides to challenge a CFPB rule, that challenge does not look like a corporation fighting a consumer. It looks like a sophisticated legal argument about constitutional structure, administrative law, and the proper separation of powers. It travels through years of litigation. It arrives before the Supreme Court in the form of an abstract question about regulatory authority, not in the form of a question about whether a bank should be allowed to charge a struggling family $30 for an overdraft. The abstraction is not accidental. It is how the game is played. And ordinary people, who do not have legal teams, who do not fund litigation organizations, who do not have the resources to wait out years of appellate proceedings, are almost entirely absent from the process that shapes the rules they live under. This is not an argument for any particular political outcome. It is a description of a structural reality. The Supreme Court wields enormous power over the financial lives of Americans. That power is exercised through doctrines and rulings that are almost never covered in personal finance media. It operates on a time horizon of years and decades, not the news cycle. And it is shaped by forces that have much more direct access to the process than any individual saver, borrower, or consumer. Knowing this does not give you the ability to change a Supreme Court ruling, but it gives you something important, an accurate map of the terrain. In February 2026, here is the landscape. Federal financial consumer protections are under sustained legal pressure in a post-Chevron environment where agencies have significantly less authority than they did 2 years ago. The specific protections that have shielded ordinary consumers from the most extractive financial practices of the past decade are being litigated across multiple federal courts simultaneously. The outcomes of those cases will be shaped, ultimately, by a Supreme Court whose composition reflects the political choices of presidential administrations going back decades. What does this mean for you, practically? It means that the baseline level of consumer financial protection you can rely on is less certain than it was 5 years ago. It means that the rules governing your credit card, your bank account, your mortgage, your student loan servicer, your debt collectors, those rules are more contestable than they have been in a generation. It means that financial literacy, understanding not just how financial products work, but how the rules governing those products are made and unmade, is not a luxury. It is a necessity. Because in an environment where the institutional protection of consumers is weakening, individual knowledge and individual vigilance have to fill more of the gap. Specifically, know the fees on every financial product you use. Read the terms when they change, and they will change. Know what dispute rights you have and how to exercise them before you need them. Understand that the protections you have today are not guaranteed to be the protections you have tomorrow. And when you see a new fee, a changed term, a reduced right, ask why. The answer often runs through a courthouse you never expected to affect your financial life. The Supreme Court's power over your bank account is not theoretical. It is not distant. It is operating right now in ongoing cases, in doctrines being applied today, in the slow rewriting of the rules of American finance. Most people will not find out until it costs them something. And by then, the window to respond has already closed. You're finding out now. That is the only advantage that matters.